I'm Mr. Jayanagar, President's Council. There is a golden thread that runs across the entire web of English criminal law: the presumption of innocence. Accused persons are presumed to be innocent until the contrary is proved. The famous observation made by Lord Sankey in the case of Wilmington versus DPP. This is the theme of my subject today. Before that, I would like to apprise you of the objectives and purpose of this channel. We found that in the 21st century, there is a digital revolution. It will be convenient to digitalize everything. These presentations that I intend to make are based on research papers and articles that I have published in law journals. So there were two schools of thought. Some of my juniors told me that we must compile all of them and publish them in the form of a book, while the others say, no, we must go on the YouTube, but that will be less costly for the viewer, and also he can choose and view what he wants. So we have selected the second option. Having said that, the main purpose is to share knowledge, enhance knowledge, share the experience. We will try to make them less academic and more practical. Initially, we wish to discuss salient features of law of evidence, criminal procedure, and criminal law. From the practitioner's point of view, there are certain issues that crop up, surfaces, appears in courts of law almost day to day, and those are the subjects that we intend to discuss. Today, without much ado, I would like to get on to my subject: fairness of a criminal trial. Now, every trial should be fair. Every trial in a court of law must be fair. Why special emphasis on criminal trials? Way back in 1785, Blackstone, a jurist, said that it's far better to allow 10 guilty people escape rather than convicting an innocent. Allow an innocent person to suffer. So even at that time, the sense of fairness was prevailing. They insist on fairness, especially in criminal trials, for the simple reason that if an accused person is convicted, criminal sanctions will visit him. He can be incarcerated, heavy fines will be imposed on him, his property can be forfeited, and eventually death sentence can be imposed. Life may be taken away. So because of which, law in its wisdom decided that it is so designed that an innocent will never ever be convicted. But it has happened in England not very far during a couple of decades ago. Still. So having said this, let us now try to find out what is a fair trial. What is a fair trial? Fair trial is a trial with fairness in which the law is administered without prejudice to any of the parties. Now that is one. The other one, that is, I think, law lexicon definition. Other one is that It is a trial held by a competent judge according to legal procedure. Blackstone. Third one, Punjab University, I think, published this in an article, which is far better, which says it's a trial held by a competent judge, by a fair prosecutor, in a calm atmosphere. They also emphasize that the fairness begins at the investigation stage. So, when a person is arrested by the police, if he's tortured and get him to confess or elicit evidence by statement after torture, he won't get a fair trial. Even before the trial begins, the investigation stage must be fair. So, these are loosely the definitions of a fair trial. It cannot be defined. It's such a wide and varied subject. It cannot be fully defined. In Sri Lanka, we have recognized this principle constitutionally. In Article 13 of the Constitution, which is fundamental rights or Bill of Rights of our Constitution, found in our Constitution, where it says when a person is arrested, he must be told why he was arrested and he must be produced before a magistrate at the shortest possible time, in any case, not later than 24 hours. Unless they can get, there are new laws where they seek the permission of court to have them in custody and question them. Those are recent amendments. When a person's liberty is restricted, it must be done according to law and he must be produced before a judicial officer for him to make appropriate decisions. Thirdly, a person who is charged in a court of law has the right to appear himself or defend himself or to obtain the services of an attorney at law. Death penalty or imprisonment would be imposed according to procedure established by law and only by a competent judicial officer. Other one is the presumption of innocence, with which I started. There are a number of authorities in Sri Lanka which has emphasized that a criminal trial must be fair. It all depends on the sense of fairness of the trial presiding judge as well. Recently, in 2008, not so recently, Justice Asoka De Silva has delivered a judgment where the jury option was not given to the accused, and he held that that is a denial of a fair trial. In this particular case, that is AG versus Segu Lebbe Latif, 2008, 1 SLR, page 225. All these judgments that I referred to will be given in the description box below. In this judgment, Justice Asoka De Silva enumerates 13 points, 13 attributes of a fair trial. There can be many more, as I said. So, I shall now conclude today. On the next day, we will start discussing one by one.